Hi, everyone, and welcome to Season 4 of Lawyers with Game. In today's episode, we're going to be talking about the Consumer Financial Protection Bureau and how they might be targeting the video game industry. Stay tuned. Hi, everyone, and welcome to Lawyers with Game. I'm your host, Darius Gambino. I am first and foremost a lifelong gamer. I've played on every home console system from the original Atari to the Sega Dreamcast to now the PlayStation 5. I'm also an intellectual property attorney with over 20 years of experience representing clients on issues related to patents, trademarks, and copyrights. I'm with the firm of Saul, Ewing in Philadelphia, and my gamer tag on the PlayStation Network is EaglesFan71. With me today is my colleague, Jason McElroy. Jason is a member of the Consumer Financial Services Litigation Group at the firm, and he routinely advises clients on issues related to consumer financial transactions. Jason, welcome to the show.
Thanks for having me, Darius. I'm excited to be here.
If you like these videos, please like and subscribe so that we can continue making them. And thank you to everyone who's already watched the first 3 seasons of Lawyers with Game. We are happy to be going into our 4th season. Keep in mind that this series is intended to be a general and very casual discussion of legal issues. It is not intended as actual legal advice. If you need actual legal advice, please reach out to us and we'll be happy to help you. So Jason, let's get right into it. We're going to talk today about the Consumer Financial Protection Bureau, which I'm going to shorten to CFPB to keep things simple. Our listeners might not necessarily make the connection between the CFPB and video games. So can you give us a little bit of background on what the CFPB does, what types of issues they typically get involved with investigating?
Sure. So the CFPB, Darius, is a relatively new federal regulator. It was created by the Dodd-Frank Act and came online in the summer of 2011. So with respect to other federal regulators and federal agencies that you typically deal with, the CFPB is kind of a baby. They're in their teenage phase right now. The CFPB is often described as the brainchild of now Senator Elizabeth Warren, and she indeed proposed the idea of a federal regulator like the CFPB prior to her election to the Senate. The Bureau really has 3 relevant types of authority for our discussion here today. The Bureau has the authority to issue regulations related to certain federal financial laws, such as the Truth in Lending Act, the Real Estate Settlement Procedures Act. They also have the authority to supervise certain companies that provide financial services to companies. So that means coming in and actually examining the policies, procedures, and what the companies do in their daily business. And finally, they have the authority to enforce certain federal consumer financial statutes. Again, for our purposes here, some of the more relevant ones for what we're going to be talking about today, Darius, are the Truth in Lending Act, the Equal Credit Opportunity Act, and the Electronic Funds Transfer Act, as well as specific statutory authority over what is known as unfair, deceptive, and abusive acts and practices in consumer financial services. The primary goal of the CFPB is to ensure that consumers are protected in the provision of financial services. So the way I typically like to look at this is an analogy to the federal prudential regulators, such as the FDIC and the OCC. The prudential regulators are commonly understood to have a mission to protect the safety and soundness of financial markets. So they're really looking to systemic market issues. The CFPB's mission is more directed toward the safety and soundness of the consumers that use the financial services. So the prudential regulators really focus on systemic risk writ large, whereas the CFPB really focuses more on individual risk to consumers from financial products. Although the CFPB is certainly concerned with systemic issues, the CFPB's focus is really on how those systemic issues affect consumers specifically.
Right. And normally I think with the CFPB, and correct me if I'm wrong, we're talking about things like home mortgages, car loans, things like that, traditional consumer-facing finance products. But they recently issued a report, and we're going to get into that later, bringing video game ecosystems within that same type of purview essentially saying that video games create microeconomies, within themselves. And one of the things that's really interesting is that after they issued this report, they put out a bunch of advertisements on LinkedIn, which we're going to put up on the screen, asking video game players to submit complaints about consumer financial transactions that are concerning to them. Have you ever seen the CFPB do something like that before, an advertising campaign?
Well, so they do advertise, well, call it an advertising campaign for complaints fairly regularly. But the ones they used here are pretty interesting because they use iconic video game scenes in them, right, Darius? So they use, scenes that you would think you might see in Super Mario Brothers or in Donkey Kong, and use taglines such as, "Has your real world coin stash been threatened by baddies?" And it really gets to the focus of what the CFPB is looking at here. As I said, they're really looking at the end user. How is the consumer being affected by these services? And are they being affected by financial services in different parts of the economy than you would typically expect to see them?
Right. And I mean, and kind of, just for people who don't understand what some of these systems are like, to explain how we got here, I mean, downloadable content and things like loot boxes have become a huge part of how video game companies make money. And you have downloadable content, and basically after you purchase the game, content in tons of games, Roblox, NBA 2K, Madden, and basically you buy tokens within those systems with real money. And then you have a currency within those systems. And in some cases, that currency, you can't do anything with it other than within the game. In some cases, you can take it out of the game. Those are rare. But essentially, the CFPB is looking at all this and saying, hey, that kind of looks like a bank account. And we're in charge of making sure that people that have bank accounts are treated fairly, right?
Yeah, absolutely. They see it, is it a bank account? Is it, a service that they're providing? Are you storing value, real value inside these accounts? And they really, they've really brought into the focus with this report we're going to talk about, but we've seen them do this in other areas too, that they start off by sort of seeking this information in the way that they're doing here through these campaigns, these advertising campaigns, to see whether a hunch that someone in the supervisory division may have has any merit to it.
So I wanted to also talk about your background and some of the litigation that you've handled, particularly anything, related to CFB enforcement actions or some of the things that that they can do. Can you talk a little bit about your past history with that?
I've been practicing for almost 20 years now. And my practice is really focused on what I call consumer protection law and issues companies face complying with various consumer protection laws and regulations. So what does that entail? That includes antitrust actions. That includes consumer finance issues, advertising of consumer products, and any of your sort of standard unfair and deceptive practices type of claims. So think of laws like the Federal Sherman Act, the FTC Act, the Truth in Lending Act, and the Real Estate Settlement Procedures Act on the federal side. And on the state side, there are often state analogs of these statutes. Many times they'll be called the State Consumer Protection Statute, a State Consumer Fraud Statute, that really get toward unfair and deceptive practices in consumer actions. And oftentimes many state laws roll in their state antitrust laws into these matters as well. So I focus on representing clients in class actions, individual consumer litigation, and government investigations and enforcement actions related to these consumer protection laws. And so that includes government agencies such as the CFPB, the Federal Trade Commission, the Department of Justice, Housing and Urban Development oftentimes gets involved, particularly with respect to mortgages, and then state attorneys general and state analogous financial regulators as well.
Now, we like to talk about video games on the program as well. I know you are a gamer for a long time. I know The Legend of Zelda is your favorite game. Talk to me a little bit about when you first started getting into playing games, and tell me about if you're still playing Zelda on newer platforms like the Nintendo Switch today.
Sure. So probably like most people of our general generation, Darius, I got into video games with a Nintendo. I mean, I had an Atari when I was younger, and I remember playing Atari, but really when I got into it was the NES. My brother got one year, I think for Christmas. It may have been his birthday. It was my older brother. He was about 7 years older than me. So, he was probably 12 or 13, and I was 5 or 6 at the time, and playing Mario Brothers, playing Excite Bike, Rad Racer, things like that. And, when I really recall getting into it was Legend of Zelda, of course, the original Legend of Zelda on NES. I just loved the adventure of it. I loved the adventure of going out and playing as if I was the hero, right? And the funny thing is, years later, when you read about when Legend of Zelda started, the whole idea of the game was recreating this childhood experience of running around neighborhoods and exploring and adventuring. And I just think it captures that so well. I loved Zelda so much as a kid. Played the original Zelda, played Legend of Zelda 2. Link to the Past was a huge one, the first one on Super Nintendo. And then as I got a little bit older, got into college and got into law school, I kind of got away from playing video games so much until my daughter was born. When my daughter was born, my wife actually, for one of Christmas or my birthday, which my birthday's the day before Christmas, so sometimes the gifts run into each other for me. But for Christmas or my birthday, one or the other, my wife got me this little Super Nintendo package. It's a tiny version of the Super Nintendo that has about 60 Super Nintendo games on it. And I started playing Legend of Zelda: Link to the Past. It just takes me right back, to being a kid. And my daughter saw me playing it. She's like, "Daddy, what's that?" And so I started explaining it to her, and she started getting into it. So we ended up getting a Switch and got Breath of the Wild, which, I mean, the difference between Link to the Past and Breath of the Wild is breathtaking. But this game, Breath of the Wild, was so amazing. And my daughter and I got into it, started playing it. Tears of the Kingdom came out. We played it. We started buying a bunch of the old Legend of Zelda games on the Switch that have been ported over, and have played a ton of them now. It really gotten back into it in the last 4 or 5 years. It's been so much fun.
That's great that you can share that with your daughter. I similarly have shared video games with my children over the years, and yeah, Breath of the Wild in particular, it came out around the same time that the Switch came out, or a little bit after, and it's just such a massive game, and the things that you can do within that game, it's very cool. And I agree, Zelda was over the years always one of my favorites as well. Continuing on with talking about video games, so one of the things that this CFPB report talks about is loot boxes, and I think we'll get into that a little bit more later. But what exactly is your takeaway from the CFPB report in terms of what might be the next steps or concerns for the video game industry?
Many times when the CFPB is stepping into a new area of financial regulation, they will begin by issuing a report similar to this. So it's important to look through the report and see what they say. What are they talking about? How do they think that it's triggering their jurisdiction or their authorities? And here the report describes multiple ways in which the CFPB believes the gaming industry is engaging in consumer financial services. And these include, in addition to loot boxes, which you already mentioned, facilitating person-to-person transfer of in-game assets. So think of, skins or virtual currency. Conversion, purchase, and issue of in-game currency, the storage of that in-game currency and or other assets that you might get, including specific mentions, again, here of skins. And then dynamic pricing of in-game assets. So you're thinking about, supply and demand type of dynamic pricing of things. What is more popular at a given time versus another? And they include a specific call out of dynamic odds, wherein the odds of obtaining certain in-game assets by chance may be discriminatory. So here's an area where they might be looking at their fair lending or discriminatory lending authorities, such as the Equal Credit Opportunity Act, or even an unfair and deceptive practice in this. So the report also identifies concerns related to data collection and utilization, particularly with respect to younger players. And we are seeing this, of course, as a bigger issue in legislative bodies in general right now, about the collection of data for younger players, younger users, how that data is collected, how that data is authorized by the parents to use it. So this is an area that we think, not just the CFPB, but legislatures in general, state legislatures and the federal legislature are generally interested in data collection about younger users. So the CFPB didn't express specific concerns about violations of specific consumer protection statutes in its report, but it does target vulnerabilities of personal video game accounts to fraud. The report also references the general lack of recourse for gamers who lose their gaming assets through fraud, manipulations, or other failures, what they call failures, of game developers to take action against unauthorized activity. So here, the CFPB specifically also notes that some developers use their terms and conditions to limit consumer recourse and require consumers to do things such as dispute charges with the company first, and sometimes may terminate accounts of consumers who are violating terms and conditions without compensation for some of those assets that we're talking about. Based on these concerns, it seems to me that the Bureau is really viewing these accounts as standard financial services in a virtual world, and they plan to approach them in a similar fashion. So a good example of what they may do happened recently with respect to services known as buy now, pay later financing, what sometimes is also known as a buy-in-for program. And the CFPB recently issued a proposed ruling treating these programs in the same manner as credit cards. So effectively what they're doing is they're saying, from this point forward, we believe that buy now, pay later programs should be treated and subject to the same regulations as credit cards in certain circumstances. So typically a report such as the one that the CFPB has issued on video games precedes later regulatory or enforcement actions by the Bureau in a manner such as we just saw with the BNPL products. Now, there have been some enforcement actions with respect to BNPL by the CFPB as well. In the last 2 years alone, the CFPB has had at least 3 or 4 different touch points in its either supervisory examinations, white papers, or other reports where it has addressed buy now, pay later before it came out with this interpretation. And I think that we're likely to see similar activity with respect to the video game industry that this report is really the first touch point on.
Yeah, no, I think the industry should definitely view it that way. A couple of the other interesting things I found in the report were they touched on money laundering and the ability to use video game accounts for money laundering purposes, especially when you have, certain skins in PUBG selling for, $50,000 or more, and they're being sold on open, unregulated websites that aren't associated with the publisher. And then the ability within Roblox to convert our US dollar to Robux. And then now within the last year, they've announced a program where you can convert Robux back to US dollars. So you can see the potential for money laundering concerns there as well. The one thing that you brought up that I think is interesting, I've been playing NBA 2K for a long time, and I know a lot of people on there wind up getting their accounts taken or banned, most times for reasons that aren't justified. And they have, let's say, $100+ worth of virtual currency sitting in that account that basically they can no longer do anything with. So, situations like that, those types of unfair results where the player doesn't really have any recourse, I think is something that the CFPB could look into as well. So yeah, let's talk about loot boxes a little bit, because that's really what it all, a lot of this comes back to when you're talking about deceptive trade practices. There was a New York Times article 2 or 3 weeks ago specifically about NBA 2K and about the loot box system within that game and within FIFA and some other sports games, where you're basically paying US dollars to buy a virtual pack of cards. And they disclose the odds to you. You can find those odds if you look hard enough. But they've basically created a system where you have to keep buying those cards in order to be competitive within the game. Is that something that you think the CFPB could take a look at?
Yeah, I think that the CFPB would likely look at this from an UDAP perspective, from their unfair, deceptive, and abusive acts and practices authority. And in particular here, what the CFPB, I think, has had an interest or has really been strong in its interpretations of recently is on the abusive side, where they see a situation where the consumer feels like it has a position of trust or position of reliance upon the company that is providing the service to it. And here we may have a situation like that where the CFPB sees a potential reliance interest by the consumer on the companies that are providing these services, and can potentially look at this in an abusive acts and practices circumstance, where they're saying you're abusing the trust in the position that you have with these consumers and the gamers that you have in your ecosystem.
Yeah, just to put a finer point on that for our listeners as well, loot boxes have been under a ton of scrutiny in the last 10 years. Kind of all began with, there was a big dust up over Star Wars Battlefront back in 2017, where there were allegations that the loot box system there was pay to win. In other words, you had to buy the loot boxes in order to do well at the game. And since that time, there's been a lot of talk about legislation in the U.S. Several countries, including Belgium, have banned loot boxes outright. So it will be interesting to see what position the CFPB takes there, because there currently is no legislation saying that you need to disclose odds or to do anything in particular when you're offering loot boxes as downloadable content within games.
Yeah, and it's an interesting point you raise, because without there being any specific statutory authority, where we see action by an agency like the CFPB here is really in trying to expand or, stretch the bounds of their authority through, what we as defense attorneys may consider to be novel interpretations of the law. So in the way I kind of look at this is CFPB is an executive agency, and the executive agencies in general, whether at the federal or state level, are creatures of statute. So they have limits on what their authorities are. And relevant to our conversation here, it's almost like their code, right? It's a code that limits the authorities and what it can do. So similar to a video game, if you look at video games, you have limits on what you can do in the game written into the code. And even in a large, open world game like Breath of the Wild or Tears of the Kingdom, we constantly have gamers who are out here trying to press the limits of what you can do in the game. What does the code allow me to do? What doesn't it allow me to do? What are ways that I can sneak through and do something here that, it's clear the game developers didn't want me to do it, but I'm kind of interested in seeing what the limits are. The CFPB does, and other executive agencies do this as well. They test the extent of their statutory authorities. So executive agencies are limited by what the U.S. Code and by what the U.S. Constitution allows them to do. That is, what powers Congress has delegated to it, similar to the way that the game developers delegate powers to you as a gamer within a game. This is one of the major pressure points with the CFPB and to a lesser extent, other executive agencies. In this world, we can think of the CFPB as sort of like a mod gamer, constantly trying to alter the code or alter what they can do within the code that restricts them in their scope and their reach. The Bureau does this through a variety of ways. They do this through new interpretations, through new enforcement actions, and sometimes through new regulations and litigation, constantly pressing the boundaries of the limits of their jurisdiction. We've got a couple of good examples of the way that they've done this. One of their very first enforcement actions was against a company called PHH Mortgage Corporation. And it was under a statute called the Real Estate Settlement Procedures Act, which is a federal statute that regulates and governs activity that can happen at home closings, real estate settlements. So in this, they took a very aggressive interpretation of the statute, which has some pretty clear exemptions. And they won in the agency administrative tribunal. And then from there, it goes up to the director. And the director at the time was Richard Cordray, who issued an opinion very favorable to the CFPB authorities. And from there, it had to go to the DC Circuit. Well, in the DC Circuit, the original opinion was favorable to PHH. The en banc opinion was less favorable to PHH. And there are some constitutional issues that were involved in there too. But at the end of the day, the circuit court said, no, CFPB, you don't have statutory authority to interpret RESPA the way that you have done here. And sometimes it, takes that kind of level of pushback against an agency for them to say, all right, we'll step back here. Similarly, they issued arbitration rules, effectively limiting the way that consumer arbitration can work. And the Senate stepped in, Congress stepped in and rejected those rules under what's known as the Congressional Review Act. But most of the time, most of the interpretations they take, the stretching, happens at lower levels than that and happens in a way that many people who aren't, as in-depth of interest in executive agencies, the CFPB, might recognize. And for loot boxes, sort of bringing this back around, where they may not have specific statutory authority, they may try and go out and use UDAP authority, or they may try to go out and use one of their other existing authorities in order to bring loot boxes into a place where they can't regulate.
Yeah, and it's like any other kind of litigation, right? If they can get an initial decision, right, regardless of whether that decision might be overturned at the director level, at the district court level, or even at the Supreme Court, if they can get one decision that says that a loot box in a particular game, violates deceptive practices laws, that may be enough to start, the other companies in the industry to think about it, really, to say, all right, well, maybe this decision, maybe they didn't have the power to actually make this decision, but do we really want to fight about it anymore? And that kind of leads me into my last question to you, which is about the Supreme Court. We just had two decisions by the Supreme Court in recent months, essentially overturning a decision from the 80s called Chevron that gave administrative bodies like the CFPB, government administrative bodies, their power. And these decisions have ostensibly curtailed that power back a little bit. So how do you think the recent Supreme Court decisions interpreting Chevron will impact the CFPB?
Yeah, so I think that, Chevron itself prevented courts from doing independent statutory analysis in certain circumstances where, an agency issues a regulation, and it has to be a regulation for Chevron. So you're interpreting a regulation, whether or not it's within the agency's statutory authority. The old standard under Chevron required courts to defer to agency reasoning on that. And the new decision that overturned Chevron tells courts, no, you do not have to defer. You have to do an independent statutory analysis of this. So I think that where this leaves us moving forward for the CFPB is that the CFPB is likely going to view their their modus operandi as not having changed. Their standing operating procedure is probably going to continue to move forward because the CFPB did a lot of actions before Chevron's overturning by interpretive guidance, by enforcement action, not by actually issuing regulations. So CFPB does issue regulations, but what we're likely to see here, particularly in the video game industry, is we're likely to see more of a situation where they're interpreting their already existing authorities in a manner that is favorable for them to regulate or enforce these laws against the video game industry. And in that case, Chevron doesn't really come into play. At that case, you're arguing a variety of different potential arguments depending on what the issue is. But Chevron deference doesn't come into play because the CFPB hasn't issued a regulation. There is another form of deference called our deference, which still technically exists after Chevron. And that is that courts in certain circumstances are to defer to reasonable interpretations of an agency's own regulations. That has been pared back a little bit in the last few years through another case from the Supreme Court. But where we're likely to see fights on this and battles on this is where does that line get drawn? Where does the line get drawn on where a court defers to the agency's authority, this case, the CFPB's authority, to regulate something like loot boxes? And that, I think, is going to take, probably some battles if it begins to happen. And sometimes we don't even see it in full litigation. Sometimes the first thing we'll see the CFPB do is they'll enter into consent orders, settlement agreements with companies that have favorable language for them. So then they can point back to the consent orders when they do have to litigate it and try to say, you see, we've had multiple consent orders. We've had this interpretation for a while. People should be aware of it by now.
Interesting stuff. Well, unfortunately, that's all the time that we have for today. I want to thank my partner, Jason McElroy, for coming on and talking about these interesting issues. We're going to have to wait and see what the CFPB does, but I think all video game companies are probably on high alert after seeing this report that came out in April. If you have any questions about any of the legal issues that we've discussed today, you can drop them into the comments, and we'll do our best to answer them without providing any real legal advice, of course. Thanks again to Jason for coming on. We will see you next time on Lawyers with Game.